Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition, we give you the top 10 defenses to a drug charge. So number one, your attorney should file a motion to suppress evidence because unless there's a search warrant, the police need a warrant or some other reason to seize the drugs. Two, there should be a written motion to exclude any statements. Now, in many states, a written motion is not required, but you want to preserve the record and protect your rights. And some of the judges say, well, you didn't file a motion to suppress any statements. Three, a motion to exclude any lab reports because under the Supreme Court Crawford decision, others decisions, there has to be a lab report. It can't just be the police saying it looked like weed, or it looked like cocaine, or it looked like whatever, or it smelled whatever. There needs to be a lab report. Four, you want to file a motion for additional discovery. For example, the machine that typically tests the drugs, what heroin, meth, whatever, is called the gas chromatograph machine. So you want the gas chromatograph results. You want proof that the machine was properly calibrated, that the people that did the testing were properly there. Next, you want to compel the state to produce any expert reports. Also, you want to file a speedy trial motion, and always file a written notice of motion to any lab reports. It has to be in writing. So let's go over again. Number one, object to the search and seizure. Now, also, sometimes there's what's called lack of actual possession. They try to do this thing called constructive possession. Someone was in the car, there's three people there, everyone was charged. Well, that's not sufficient. Also, in rare cases, there's entrapment where, a young police officer pretending to be someone goes, hey, go get me some weed, and they keep on following the person and try to bum them. Now, even if there's drugs in the car and that's the only person, we mentioned constructive possession, but they have to prove that the defendant possessed the drugs, knew or should have known that it was there. Now, it's difficult for someone to convince a judge if the drugs were in someone's pocket, but car, apartment, house, whatever. Let's say, were the drugs properly tested. Now, the last couple things we're going to talk about is PTI, conditional discharge. Those are the deferred prosecution programs, often for first-time offenders. If someone stays out of trouble, a year, 2 years, the charge gets dismissed. More and more, though, if people can prove, even if they have priors, if someone can prove that they have an addiction problem and they're seeking treatment, some prosecutors will work with them. New Jersey, for example, has a thing called the drug court. And finally, people with pot charges sometimes will go out and get a medical marijuana card afterwards. I'd say it works with some prosecutors. It doesn't work with all of them, but if someone can get a medical marijuana card, that is something good. For more information on defending drug charges, please visit our website, njlaws.com, njlaws.com. And for representation, contact Ken Vercammen's office in Edison at 732-572-0500, or email us through the link on our website, njlaws.com. Thank you.